So here are the objectives for our discussion on informed consent today. These should be available to you in your packet, so I won't spend time going through each of those. Let's get to it. So with medical informed consent, how do you define it? And I thought this group gave an excellent definition, and I wanted to put it in there for your reference. And the point is that it's an exchange of ideas focused on this fiduciary relationship between the patient and the physician, and that it's an educational process. And the idea is, while the patient is not going to know as much about their condition as you do, you try to give them all the details you can so that they're as close to where you are as possible when they're coming to make that decision. So you want them to be fully educated so that there aren't any surprises and they can really decide what they want to do. You're supposed to disclose a variety of things to the patient. You tell them that, what the diagnosis is, what you think it is, what the differential is, the nature and purpose of the intervention, the risks and benefits of doing something or not doing something or doing an alternative. And this can be stated many different ways in different journal articles and state laws, but this is the nuts and bolts of that educational process that takes place with any informed consent. And the discussion really should be directly between you and the patient. This isn't something that you should routinely contract out to any kind of staff or any sort of printout. If you're the surgeon that's about to do the hernia repair, I doubt that you're going to be asking a nurse or anybody else who works with you to sort of go over all the risks with the patient. You're going to want to discuss the CT scan that you took beforehand and all those things with the patient yourself and tell them what the risks are. Okay. And many applications of informed consent laws. So there are price transparency efforts that have been attempted at various state levels. To my knowledge, none of these have really had the intended effect that I would like to see in terms of informed consent. You see it come up with specific areas, which we'll get into here in a minute. We'll talk about some examples, and those can involve vaccinations. This was an issue even before COVID, and it's certainly at the forefront now. It comes up often in state abortion laws with consent for minors for various medical procedures. When can they do these things? And they often vary by age and by state in ways that make you scratch your head. So I put the quote up there, "Scare him into it," because I heard this from one of my attendings in residency. And, it came up in multiple contexts where they thought a patient should be doing a certain procedure and the patient didn't want to do it. And the decision to not do it seemed irrational to that attending physician and to many others involved in the patient's care. And the implication behind that statement is that you haven't discussed it in enough, maybe gory detail, if you will, with the patient, and that they don't understand what they're trying to do. And maybe that's accurate sometimes, and maybe other times it's inaccurate and indicates a clinician bias that is going to come across in this informed consent educational process. So, examples would be colonoscopy, which of course is an excellent screening for colon cancer. But are you, when you discuss that with your patients, are you going over the exact numbers for colonoscopy versus flexible sigmoidoscopy versus, a CT scan versus stool hemoccult versus fit testing? Are you sort of really going over the detailed numbers? Or are you sort of saying, when do you want to do your colonoscopy, and hoping they'll say yes and really not going into other alternatives that are out there? There is a risk of perforation with colonoscopy, even though that's low, and that should be discussed when you're talking about these different screening options. Vaccinations, are you talking about how many cases of, let's say, influenza or COVID you think have been prevented from the vaccine? Are you discussing what the number needed to treat is to make a difference? Do you even have that information to go over it with the patient? Are you routinely discussing the adverse event reporting system with patients? There's only so much time, and you have to sort of decide what you're going to emphasize. So I mentioned that on sort of the earlier slide, but with colon cancer, there's lots of different screening options. And going over all these things can make a difference. Even though Medicare and other insurance companies do cover colonoscopies, typically without any out-of-pocket costs. You've got a lot of patients who don't want to do them, and about 60% of people who are eligible for that, supposedly at no cost, actually do it. So state by state, there are lots of variances about how they really define it. Some of them explicitly define it in statute, and others don't seem to do that. And these definitions can vary quite a bit from one to the other when they're offered, and they're often offered in the context of specific things, such as vaccination or minor or pediatric consent issues and abortion. And really, the black box warning system, in my opinion, is another effort at informed consent that's attempting to move a specific detail or two that was on a laundry list of 50 or 100 to the top of the list. They're attempting to make sure that it's discussed because they find that the FDA, I should say, finds that to be something that's especially worth the patient's time to go over. So here's one example out of Nebraska. Informed consent shall mean consent to a procedure based on information which would ordinarily be provided to the patient under like circumstances by healthcare providers engaged in a similar practice in the locality or similar localities. Failure to obtain informed consent shall include failure to obtain any expressed or implied consent for any operation, treatment, or procedure. So this talk today isn't necessarily indicate, my desire was not to get into express versus implied consent. That's a legal talk for another day. But the notion is that you're always going to get some sort of consent before a procedure or intervention. And if you can't get the consent from a patient that's talking to you and going over it, then you have to find another way to get the consent, which of course there's emergency implied consent in certain settings, and that's why we have advanced directives. Notably, there are drug advertisements are permitted in the United States. And I think this is an interesting policy debate. They're also permitted in New Zealand, but other than that, I think they're illegal across the world. And the notion is that if a medication is so dangerous, the patient can't purchase it over the counter, how in the world can you expect to advertise it in a fair manner that has anything close to some sort of informed consent in a simple brief TV or radio ad or a one-pager in a magazine? And there really is no green light process for ads from the FDA. They do have a process where they will say you can't say certain things, but that's more after the fact, and it's policed in a way that is still debated. And the FTC is the one who regulates over-the-counter medications, which is different than the FDA. So what does the FDA say you need to have? They say, well, you got to have at least one approved use for the medication. You need to use the generic name. And you need to show all the risks of using the drug. And then under certain circumstances, they say only the most important risks. So usually something that actually discusses all the risks turns that one-page ad into 4 or 5 pages, which you've probably seen in many different journals that even we read, which are often available to patients as well. And that's the fine print. What are ads not required to tell you? The cost, or if there's a generic version available, or if there's a similar drug with fewer or different risks. So what are they sort of admitting here right off the top is that an ad, of course, which we all know, fails at any kind of effort of informed consent because it doesn't include all those things that need to be there. That's one more reason why this needs to be an educational conversation directly between the physician and the patient. The FDA does expect patients to read things other than prescribing information, which is what we read when we're reading a document that's actually printed, that's agreed to between the FDA and the pharmaceutical manufacturer. That's the 20, 30, 40 pager about the medication. And the FDA doesn't expect the patient to go through that because they generally think that the patient doesn't have an educational level that's high enough to actually read and make sense of it. They do expect patients to see brief summary documents, major statement documents, and adequate provision types of things that can show up on broadcast ads. And that's probably the area that gets debated the most. And then probably 20 years or so, they started adding these black box warnings to medications. And often they were adding these much later. Medication might have been on the market for decades. In the case of ranitidine, it would have been severe enough that they just removed it from the market. So you don't truly know the risks of medication initially, or any intervention initially. If something causes side effects years down the road, it takes years to figure it out. And about 40% of Americans are taking a medication that has a black box warning. And so we'll go over a few examples of these. It seems like they've been adding more over the past 10 years than they did before that, and to medications that were previously thought to be safer than maybe they really are. And the tacit message, which annoys me, both as a physician and an attorney, is that all those other risks that we previously had you list and maybe made you liable for and wanted you to transfer to the patient in some way through an educational informed consent conversation, we're saying that those really aren't that important. That's why we have to put things in a black box here so that you'll actually emphasize them, because we had so much clutter in the prior discussion that you couldn't find the actual important needles in that haystack. So with the Montelukast example, FDA made this announcement in March of 2020, after the medication had been on the market for over a decade, that you can have some serious neuropsychiatric events that could include suicidal thoughts or actions, and that the only use for Montelukast should in fact be for patients who've had an inadequate response or intolerance to alternative therapies, and that you want to go over the risks and benefits. So for your asthmatics, for your allergic patients, they should have already tried antihistamines, inhaled corticosteroids, intranasal steroids. That's the implication here, and that Montelukast should sort of be your last ditch effort. And for a lot of patients who've been on this a long time, this was a head scratcher, especially if they hadn't had any of these side effects, but now you need to make sure you go over it. Isotretinoin has a black box warning, and in addition to that, it has a pledge. So you've got a lot of patients who want to take this for acne. Often these are female patients who are in their reproductive years. And the last thing you want to do is cause a major birth defect while you're trying to treat something cosmetic like acne. So they do have a requirement that the people prescribing this medication have to register with this iPledge, and then actually go over that in great detail and have a patient sign each portion of it, making sure that there's no way they're going to get pregnant while taking this medication. This is fairly uncommon, but it's an example in my mind of the FDA saying, we view this particular piece of informed consent to be extremely important, so we're going to tell you exactly how we want you to do it. Safety data can take time, as I mentioned earlier. So 71 of the 222 medications approved in the first decade of the millennium were ultimately withdrawn or required a black box warning that was added after the fact. And this usually happened around 4.2 years after the medication was on the market. So people often talk about informed consent. Fellow physicians, I should say, have asked me about this, and they bring it up and say, well, if I did enough informed consent, then the patient can't sue me for this particular complication of the procedure because, hey, I told him it can happen in advance. And that's not really accurate. You do want to tell the patient about the risks of the procedure, but if the risk of a complication of the surgery you're about to perform is a 1 in 100,000, and it happens, then you are going to face some malpractice liability from that, even though you disclosed it in advance. It's simply rare enough that a jury is likely to find malpractice liability. So you're doing that to limit that liability sum in the malpractice setting. In the battery setting, you can get rid of all liability. So remember, battery is fairly simple. A lot of people confuse assault and battery. Assault is when you yell at somebody and tell them you're going to hurt them and you're running at them with a baseball bat. That's assault. Battery is when you actually hit them. So if you sucker punch somebody, you've committed battery but not assault because they didn't see it coming. It's an unconsented touching. So you can have this happen in the surgical setting. It's fairly rare now because we've thought about these things, but let's say, 70 years ago, some surgeon goes in to do what they think is going to be an emergency appendectomy. They start looking at the appendix once they're in there and they say, well, there's nothing wrong with this appendix. This is actually a gallbladder issue because they can see the gallbladder is, necrotic and needs to be removed. So they remove the gallbladder instead. But before the procedure, what did they have the consent to do? They had the consent for the appendix. And then you have this debate about, did you have implied consent in the emergency because the gallbladder was sick enough, or did you commit some sort of battery because you now removed a gallbladder when you didn't have consent to do that? Allegations of failure to obtain informed consent for spinal surgery. This was a neat study that I thought was worth kind of going over. So you've got 80 patients that had these were malpractice claims, and 80 of them alleged that there was no informed consent allegation. They didn't have an informed consent allegation, and you had 153 who cited lack of informed consent. And the most common reason they said they didn't have informed consent was failure to go over enough risks and adverse effects of surgery, or to explain alternative treatments. And it tended to be that people who were suing with informed consent claims had weaker overall medical malpractice claims, and that's why they relied on the informed consent argument. And if they were relying exclusively on the informed consent argument, the physician was more likely to have a favorable defense verdict. So anecdotally, this has been my just sort of conversations with other attorneys. I think they would echo this, that if the only argument is one that's focused on informed consent, it's less likely to lead to malpractice claim in that plaintiff's favor. Informed consent disclosure to vaccine trial subjects at risk of COVID-19 worsening clinical disease. So this was a timely article in 2021, and they said that vaccines for SARS, MERS, RSV have not been approved. So are these kinds of things being discussed with patients, and that this may worsen COVID-19 disease via antibody-dependent enhancement, which was a fear and probably remains a fear in terms of future variants of the virus? Was that discussed with patients? And they said adequate patient comprehension of this risk is unlikely to occur, and that you really didn't have informed consent by subjects in these trials because you didn't go over that antibody-dependent enhancement risk. Informed consent to an obligatory vaccination. So here, this was a good argument, and this is backed up by the World Health Organization. You'll see in some other slides. Every medical intervention should be preceded by informed consent. That would include vaccination. However, informed consent in the case of an obligatory vaccination cannot be voluntary and valid. Which makes sense. If it's an obligatory vaccine, you've removed the voluntary. And if they have to do it, then you don't really have a decision. So what's the point in educating someone who doesn't get to make a decision about what's being discussed? Asking patients to sign an informed consent form is paradoxical in a situation where not signing it will lead to legal consequences. So the sign this or else, that's signed under duress, and in contract law, we would say the entire contract is now invalid. So unlike informed consent, there should be a responsibility transfer from parents to entities responsible for vaccine obligation. So this one was in the context of pediatric vaccines. What is more, when discussing vaccinations that are mandatory, we postulate that informed consent shaped by medical sciences and required by law should be replaced by a simple signature on an appropriate document confirming that vaccination occurred. This would not confuse the parents that they had choice nor burden with them about this difficult decision. Okay, so World Health Organization makes a distinction between consent versus assent. And consent, they say, the individual must give their permission. And for this consent to be valid, it has to be informed, understood, and voluntary, and that the person consenting must have the capacity to make the decision. And they distinguish consent from assent, and assent would be something closer to what you could maybe do in a mandatory vaccination setting, or maybe in a pediatric setting where the parents are saying and agreeing something's going to be done, but the child doesn't want the vaccine. And depending on the age, that child might simply not want to have a needle go into their arm, which is entirely rational for a 3 or 4-year-old. So there you're talking about an assent process rather than consent. And the legal age of consent varies. It varies by country. It varies in the United States by state, depending on what procedure is being discussed or what medication is being discussed. And some countries have fixed the age of consent to specifically allow HPV vaccination starting at 12 years. It's one of the more recent conversations out of the World Health Organization. But there are lots of other examples in the United States as well. Colorado is one where you can have informed consent for birth control at any age, for abortion at any age, and that notice to the parents is required in some circumstances, but not all. And you can have a minor who's 15 years of age or older consent to receive mental health services. And it could be screened for STDs or addiction at any age, which is an interesting dichotomy right there, right away. I don't know if anybody in the audience is practicing psychiatry or routinely doing addiction medicine, but of course you can have someone who's addicted to a substance prior to age 15, and that is considered a mental health condition. So you've got one portion of the law saying addiction at any age and another saying mental health only at 15 or above. So when the state tries to get involved in great detail like this, people who practice medicine immediately start spotting holes and areas of law that conflict with one another. Informed or misinformed consent, abortion policy in the United States. So this was another article, and the authors have lots of different opinions in there, but one that sort of was worth quoting. We find that nearly 1/3 of informed consent information is medically inaccurate. So it might have been accurate at one point, or maybe physicians didn't necessarily agree, but a policymaker agreed with a specific physician on a specific issue, and then that wound up in the law. Well, maybe it was right at some point, but is no longer medically accurate as science changes over time and new studies come out over time. So in summary, price should be a component of informed consent, and informed consent should be more about education. This requires time spent with the patient in direct conversation, and you really can't achieve this with a specific handout or signature. And liability can shift as this education increases, and that does happen. That's what the government's trying to do with a black box warning. That's what a manufacturer is trying to do from a product liability standpoint when they try to make certain risks very apparent so that you will share them with the patient so that the patient won't pass them on to you and then pass them on to the manufacturer. And a complete treatment mandate for a vaccine or any other intervention, if it becomes required, then it really renders the informed consent process moot, and you shouldn't put the patient through signing some document that's attempting to transfer some of that risk and some of that liability when they don't have a decision to make in the matter. And I would say that we're living in an ironic time where where information is infinite, but no time is committed to these discussions. And that what really matters isn't information as much as education, and that you can't make a decision or transfer risk without that education. So here's a little bit of recommended reading. And there's my email in case anybody has questions, and then we can certainly do a Q&A now as well.
Well, thank you very much, Dr. Eskew. We have about 6 minutes for Q&A. And I will say that I once participated in a sham peer review case where the ER physician was helping to treat a patient who came in on multiple drugs and was, of course, cognitively impaired, couldn't sign anything at that point, was all over the cart. And he was trying to hold the patient down along with some nurses so the patient wouldn't fall off the cart and get hurt. Because he touched her and tried to hold her down so she would not get hurt, after the patient was discharged, she went to the sheriff's office, filed a complaint of battery against him. And the local sheriff refused to arrest the doctor. But that's another case of battery in the ER. So we'll take the next question, please.
Hi, my name is Bill Mueller. I appreciate your talk. I had a question about that last bullet on that last slide. I don't really understand how informed consent could ever be moot, because it seems like patients should always actually have the ability to say yes or no. And I understand we're talking about adults here and not minors, but if you could clarify that, and then maybe speak briefly about the, I guess, the legality or the moral ethics of the informed consent that is being used to administer the vaccines at this time under the emergency use authorization. Thank you.
So the last slide, that maybe I should have reworded it a little bit, but the point isn't that I would want to ever get rid of informed consent. The point is that we shouldn't call it informed consent if the intervention is mandatory. So informed consent is an educational process by which the patient is educated and then has a chance at making a decision, a yes or no decision. And if we make an intervention mandatory and then say we're going to go through informed consent, and not only is this intervention mandatory, you have to sign this document, then we're confusing everyone, because that, I would argue that informed consent document wasn't an effective informed consent because it was mandatory, and that it was a agreement that was a contract signed under duress, and it's also unenforceable. And as far as the vaccine mandates, that gets messy on a lot of levels. That's head scratching to me, and maybe smarter attorneys like Andy Schlafly will have a better sort of big picture view of this. But I find the mechanisms by which the government is attempting to mandate it to be, I don't know if they're carefully thought out or if they're just the quickest ways to do it. So, right now it's happening through proposals through OSHA, and they're, doing it based on employers and based on size of these entities. And so in a way, the government is trying to transfer this risk of litigation from themselves to the employers based on their size through OSHA. And that, I have no idea how this is all going to play out.
Okay, we'll take two more brief questions, please.
How do you reconcile the concept of HIPAA and healthcare privacy with being forced to disclose vaccination status and for almost anything, even if getting a prescription in the pharmacy, the pharmacist asks you, that kind of thing?
HIPAA has, the P in HIPAA is for portability, not privacy. And when you have different entities asking for this status, you don't, as far as I know, there's not a group where you really have to disclose it. And even right now, a lot of the mandates that are being imposed on employers are technically testing mandates rather than vaccination mandates, because they're saying, if you've got some list that's supposed to be confidential and not open access to everyone that says who's been vaccinated, and you need to be routinely testing everyone who has not been vaccinated. And if they don't, get the vaccine, then they have to do this test every week. So when people are, as far as I know, when various entities are asking you for this information, it's kind of like somebody knocking on your door without a warrant, asking if they can come in and search your house. If you say yes, then they're going to come in and search. But if you don't answer the question, then you simply didn't answer the question. And I don't think, I'm not aware of a situation where you have to answer that question.
Final question.
Thank you. The Smith-Mundt Modernization Act of 2012 allows our intelligence community and our public radio, NPR, Voice of America, to use propaganda on the United States people. Previously, it wasn't allowed to be used on the United States people, so hence the fake news. How do we, as physicians who are under obligation to tell the truth to our patients, combat an intelligence community and a news media that is allowed to lie to our patients?
I don't, I think I'll rephrase it a little bit. Like, in this information age, how do you know what's true and what's not when you have all this clutter out there and plenty of misinformation? And I guess as a family physician, my answer is that's why you have this ongoing treatment relationship with the patient. Just like you trust your friends more than you trust some random person that you walk in, that you run into at the grocery store. You have that relationship with them. You've decided this person is intelligent enough that you want to seek their advice and their counsel. And that's what we do at times like these. We sort of turn to the people we know and trust.